Trial in absentia is a criminal proceeding in a court of law in which the person who is subject to it is not physically present at those proceedings. In absentia is Latin for in absence. Its meaning varies by jurisdiction and legal system. In common law legal systems, the phrase is more than a spatial description. In these systems it suggests a recognition of a violation to a defendant's right to be present in court proceedings in a criminal trial. Conviction in a trial in which a defendant is not present to answer the charges is held to be a violation of natural justice. Specifically, it violates the second principle of natural justice, audi alterum partem. In some civil law legal systems, such as that of Italy, absentia is a recognized and accepted defensive strategy. Such trials may require the presence of the defendant's lawyer, depending on the country. Member states of the Council of Europe that are party to the European Convention on Human Rights are bound to adhere to Article 6 of the Convention, which protects the right to a fair trial. Trials in absentia are banned in some member states of the EU and permitted in others, posing significant problems for the fluidity of mutual recognition of these judicial judgments. The executing member state possesses some degree of discretion and is not obliged to execute a European arrest warrant if the country that is making the request has already tried that person in absentia. Conditions under which trials in absentia must be recognized include: if the person can be said to have been aware of the trial, if a counselor took their place at the trial, if they do not request an appeal in due time, and if they are to be offered an appeal. The framework decision on the European arrest warrant provides for the legal guarantees relevant to trials in absentia, while the framework decision explicitly refers to Article 6 of the European Convention on Human Rights. Its purpose is not to harmonize national laws on trials in absentia but to provide terms for the non-recognition of a European arrest warrant and other cooperative tools. The framework decision provides detailed conditions and requirements on which a trial in absentia can be considered compatible with Article 6. The right to a fair trial. According to Peter Klepp of the think tank Open Europe, in parts of Europe, in absentia trials essentially give defendants the ability to appeal twice, asking for a retrial at which they would be present and then potentially appealing the second verdict. There are some guarantees in the legal system that make sure that it's fair, that the rights of the defense are not being violated, while still making sure that justice is being done. In absentia judgments are common. You can criticize that, but it's quite common. The Council of Europe has made commentary on judgments that are made in absentia. The Committee of Ministers, in Resolution 11, of the 21st of May 1975, stated that an individual must first be effectively served with a summons prior to being tried. In this sense, the ministers are emphasizing that it is not the presence of the accused at the hearing that is of importance. Rather, the focus should be on whether or not the individual was informed of the trial in time. In a 1985 judgment in the case Calosa v. Italy, the European Court of Human Rights stressed that a person charged with a criminal offense is entitled to take part in the hearings. This entitlement is based on the right to a fair trial and the right to a defense, both of which are required by the Convention. Furthermore, the court stressed that a person convicted in absentia shall be entitled to a fresh trial once he becomes aware of the proceedings. When domestic law permits a trial to be held notwithstanding the absence of a person charged with a criminal offense, who is in Mr. Kalotza's position, that person should, once he becomes aware of the proceedings, be able to obtain, from a court which has heard him, a fresh determination of the merits of the charge. The Human Rights Committee examined Monguia Mbange v. Zaire, in which the applicant was sentenced to death while exiled in Belgium and was only able to learn of the case against him through the media. Due to these circumstances, the committee found that a number of the applicant's procedural rights had been violated, especially in consideration of the fact that the Zairean authorities had hardly attempted to contact the applicant despite possible knowledge of the applicant's address. This highly impeded the applicant's capacity to prepare any form of defense. Failed evidence to support the case that a court had tried to inform the accused of proceedings against him, Her provides the committee with the opinion that the right to be tried in one's presence was violated under Article 8 of the Charter of Fundamental Rights and Basic Freedoms of the Czech Republic, which has the same legal standing as the Czech Constitution. No one may be prosecuted or